All right, everybody. So we're going to go ahead and start. Welcome to New Mexico Family Advocacy Program's third 2020 ECHO presentation. NMFAP is a model of respondent parent representation being implemented in the 13th and the 2nd judicial districts that utilizes interdisciplinary teams of lawyers, social workers, and parent mentors working effectively together to provide quality representation and the advocacy and support families need for reunification or other preferred outcomes in the child welfare system. As participants in our community of practice, you will receive professional development from experts and early adopters of the NMFAP model, learn best practices, and collaborate to solve issues that present challenges to providing quality parent representation in the court systems. I am Andrea Gunderson. I'm one of the lead attorneys of the NMFAP program, and I'll be facilitating today's workshop. Jen, can you introduce yourself?
I'm Jennifer Vera at the AOC. I'll be providing technical support today. If you are on the phone, doesn't look like anybody is, but if you do end up on the phone, just press *6 to mute and unmute. And if you have any other questions, you can also text me directly if there's any issues.
Thanks, Jen. Can we have the other NMFAP leads introduce themselves?
I am Caitlin DPR. I'm one of the lead social workers for the program.
Hi, I'm Leslie Jones. I'm one of the lead attorneys for the program.
Catherine Brock, one of the lead social workers for the program.
I'm Quiva Hubbard. I'm the parent mentor coordinator for the program.
Hi, Camille Hancock, one of the lead social workers for the program.
Okay, I think we also have Corey Griffith, who is our boss and fearless leader. If we can all please remember to complete our post-session feedback and reflection forms. Funding for our professional learning through NMFAP ECHO comes from federal grants, so these surveys are very important to the program's broader evaluation and continued funding. Practitioners, please sign up to present a case or issue for our next problem-solving issue processing session on May 5th. Our session announcements contain links to the sign-up form and case presentation form, so go ahead and complete those and send them back to Jen as soon as you can. The workshop that we have today is titled In and Out of Court Advocacy for Less Restrictive Visitation from Day One, and our workshop is going to be presented by Estelí Juárez. Estelí Juárez is a 7th generation New Mexican. She graduated from UNM School of Law in 2009 and has been in practice ever since. She's a 5-time super lawyer rising star, a published author, an Emerge New Mexico, Wellstone Action, and Emily's List graduate, a certified yoga instructor, postpartum doula, and a mother of 4 boys. Her legal career has been focused on families, and she's covered the gamut of family-associated cases, domestic relations and domestic violence, adult and kinship guardianships, wills and trusts, and probate. Estelí has been practicing in the abuse and neglect field for the last 3 years in the 13th and 2nd judicial districts. And our learning objectives for today are threefold. 1, participants will be able to identify early case events which provide the opportunity for advocacy for less restrictive family time for parents whose children are in CYFD custody. 2, participants will know what information to get from their clients in CYFD that can be useful when advocating for less restrictive family time. And 3, participants will have tools for negotiating with CYFD out of court and for litigating requests for less restrictive family time in court. If you guys want to ask questions during the presentation, I would ask that you go ahead and do that in the chat box, and then we'll get to those at the end of the presentation. And now I will turn it over to Estelí. Let me get your PowerPoint presentation up, okay?
Awesome. Hi, everybody.
Hello.
All right, go ahead, Estelí.
Thank you. Hi, I'm Estelí, and I think I know most of you. If I don't, it's nice to meet you all. This is not my preferred method of meeting people or presenting, so cut me some slack, please. I can't, hold on one second. I am looking at Andrea, sorry. And not that I don't want to look at you. It would just be, okay, here we go. So I originally wanted to do an interpretive dance, but then Corey yesterday was like, no, that's not really an option. There's got to be like a PowerPoint. So I put together this PowerPoint and it's not great, cut me a little slack, but I'm hoping that by the end we can kind of flesh out some of the stuff that I want to talk about, and that the things that didn't make it onto the slides will get there. And then if we can, I can make some edits later if we need to. So today we're going to talk about in and out of court advocacy for less restrictive visitation from day one. Some of this presentation will talk about things other than visitation and how we do in and out of court advocacy for those things, but we'll get there when we get there. So I guess let's go to the next slide and see what's going on. So the first slide is about Cornerstone advocacy. And I don't know if you guys can see this, but Cornerstone tells us that visitation should be frequent and as long as possible, and in settings that most closely mimic family life. A couple of other things that if you've been paying attention to your Cornerstone stuff, or you've been going to the meetings that Cornerstone has been focused on, is supervised versus unsupervised visits. How do we make that determination? And so right off the bat is going to be the threat to the child. Are we dealing with a case where there is an impending threat for an unsupervised visit? Are we dealing with a parent who might abscond with a child, a parent who might continue to abuse or manipulate a child? If we're not looking at any of those kinds of immediate threats, then we should be advocating for unsupervised visits right away. A lot of times, well, always, right? The department comes in and they want supervised visits. And most of the time we all kind of just go along. And one of the biggest things I feel like Cornerstone is pushing us to do in terms of shaping or forming our advocacy is to push back at every point that we can, if it's appropriate, right? One of the things that Andrea said when we first got on and she was talking about what we do here, it's about resolving the cases with reunification or whatever is the best option for the family that we're working with. So first, we're talking about supervised versus unsupervised visits. If we can't breach unsupervised and the visits have to be supervised, then we can talk about whether or not we're going to do them at a visitation center, at CYFD, or with the visit host. And visit host is the thing that we've been talking about a lot in the last calendar year, and how do we start moving the department and the court and kind of everyone to start opening up to the idea of visit hosts who are not, right, members of the department, are not people that are employed to do this. They're people in the community, members of the family or friends of the family. Oftentimes when we come into these cases, we're looking for placement options, and everybody can't be a placement option, but people are more willing to do visit hosting if they can help out. People do want to help out the people in their community. They want to help out their families, but sometimes the options are so limited, right? It's either you can take the kids or you're of no help. Visit hosts help us expand the community and really show the parents how much support they have when the kids come home, so that they can continue to engage in those kinds of supportive community efforts when the kids have been returned. So when we're talking about whether or not we need a visitation center or a CYFD visit or a visit host, we want to look at what are the conditions that brought the child into custody? What are the ages of the children? Are there any therapeutic recommendations at this time? And if there are therapeutic recommendations, how frequently are we reassessing that? If I, in my cases, get a recommendation that visitations are not therapeutically recommended at this time, I will request almost every 30 days for an update. Hold on one second. Please come in. Yes, it's free time, but I'm on my meeting, so could you go? What do you need, sir? I'm using it. Go, please. Thank you. Sorry. So I forgot to tell everyone in advance. Those 4 children I have, they're here in my house. So sorry about that. We're at free time on our curriculum schedule, so that's what they're doing now. So when we're talking about therapeutic recommendations, we want to be getting new ones. We want to keep assessing, because ideally, right, the therapies working in situations are changing. Parents are engaging in therapy, kids are engaging in therapy. On the best case scenario, they're either doing that at the same location, or those therapists are at least exchanging information so that we are moving this family forward therapeutically to be able to be reunified. And the last thing is the child's reaction to the visits. And I'll talk about that a little bit more later on in the slides about trauma and trauma-informed practice, and how were we as attorneys, and everybody on the team really, although I credit the social workers a lot more than I credit attorneys with doing the research and being knowledgeable on trauma-informed practices, no offense guys, but lawyers aren't always great at that. And how are we assessing cases, and how are we accruing knowledge so that we are more informed about what it is that we're doing and what effect the things that we do have on the families that we work with. And most of all, I feel like Cornerstone Advocacy is asking us to look at this case with this set of facts, with this family, right? We're not going to, this is what normally happens, or typically in a case like this, right? Those are predictive measures that we can use to help clients understand what the possibilities are. But really what we should be doing every time is assessing this particular case and figuring out what is in the best interest of this family. So if we go to the next slide. Boom, yay. So my slides have funny names. So this is about a shift. And for me, I think of like a paradigm shift. How are we practicing differently in an interdisciplinary method than any of us typically do in our regular day-to-day job that's not this interdisciplinarily focused? So the first thing we want to know is, what do we want? What is the desired outcome, and how specific can we get about what we want? So even as early as custody hearings, right, we need to be talking, number one, to our clients. A lot of times we are going with the idea, right, more visits, longer visits, the most visits we can get. But I can tell you, I sat in a custody hearing once, I argued for that, and my client was like, oh no, I work, X, Y, and Z days a week. I can't do that. So we really need to be communicating with our client first and foremost to figure out what schedule works best for them. What's normal in their life? What are they usually doing? For example, if you have like a parent who's not living with the kids, you have a dad maybe who sees the kids every other weekend. And so what does that visitation look like now that the kids are coming into custody? And so getting very clear with our clients about what they want, what works best for them, what's normal in their family. And then when we make our requests, how specific can we get, right? So we want, cases coming in, I have a 3-month-old baby and a 2-year-old toddler, and I really want 3 visits a week for 1 hour at a time. Showing up and saying, hey, we want more visits, we want more, is not enough, I feel, in my practice, right, to get the judge to hear me and to get the department to understand what I'm advocating for. So very specifically, this is what I want. My client wants 3 visits a week at 1 hour a visit. And why? Why do we want that? What's our reasoning? What facts or theories are we relying on? And this goes back to a little bit of what I was talking about in the last slide about what information are we accruing outside of our work, and how are we collecting all of that to be more effective? So if we're talking about child development, right, and we're talking about what do kids in this age range of 0 to 3 years, what's the most ideal kind of visitation? Well, kids that little really need frequent visitation, but it doesn't have to be very long. It can be 45 minutes to an hour, but we really want, I want kids in there 3 to 5 times a week. I had a case down in Valencia where I was a guardian ad litem, and I got 4 visits a week. Mom and dad each did 2 visits a week every other day. So dad came down Mondays and Wednesdays, mom came down Tuesdays and Thursdays, and that kid, who was about 1.5 years when he came into custody, got to see his parents almost every day of the week. And so advocating for longer time may not be appropriate. Advocating for more frequent visits maybe, or vice versa, right? If we're dealing with older kids, an hour is not long enough. Maybe we want a 4-hour visit, right? So that there's enough time to do homework and talk about school and watch a movie or cook something and engage in that way. So getting very specific about what it is that we want, and then what are we relying on? Are we relying on child development? Are we relying on what's normal for this family? Are we relying on what are the options available to us when it comes to visit hosts or visit centers? How are we framing what we want? And then what are we using to back that up? And then who do we want it from? Who's the decider? Who do we have to convince, right? Is it the judge? Is it the department? Is it a therapist? Where are we making the arguments that we need to make in order to get the results that we want? Not everything, as we know, and I'll talk about this later on, is decided by a judge. Plenty of things are up to the discretion of the department. So how are we engaging with the department, and how are we having these discussions with these workers and their supervisors and their lawyers in a way that helps them to see the point that we're trying to make? And then lastly, who can we get on board, right? We're talking about interdisciplinary work. We have a whole team here. So are there teammates that can help us get to where we want to go? Or is there someone on the team that knows more than we do, right? If I want X, Y, and Z visitation, but I don't know about child development, or I don't know about trauma-informed, decision-making around visits, then who can I turn to on the team and say, hey, Caitlin, what can you tell me about these things? Or I want to do this in this case. And it may not even be a case that Caitlin's on, but that's the point of working this way, right? Is that we get to rely on each other. So calling each other up or texting each other and saying, hey, I want to do this in this case, or I have this thing and I have questions about how this would work, or what would you recommend? The point of the interdisciplinary team is to rely on other people's knowledge, right? Is to be able to work together really to get the outcomes that are best for these families. And I will I think some of this may be addressed a little bit more to lawyers, but we have a role in our advocacy to get things done the way ideally that the client wants them. Sometimes maybe we do them the way that we want them, depending on the case and how we're feeling and what's going on with our egos. But this team exists so that we can all kind of call on each other so that we're making the most informed decisions and that we're approaching our advocacy from the most reliable and concrete place, right? With the most information and the most facts that we can in order to sway or to convince or to get people to change their perspective, to make that shift, right, about what we're talking about in terms of early intervention, in terms of expanding visits, and how are we helping families get back on track as soon as possible with the way that we're engaging in visits. Next slide. Know when to hold them and know when to fold them. So where is the advocacy occurring and what are the goals there? So I am, and I know that there are social workers on this call. I have been in pre-perms before, and when the department says we're changing the plan, I will say, okay, depending on the energy in the room and the ability to, to have a discussion, I'll say, okay, we're done. I don't need to hear anything else because my argument doesn't happen here, right? If I know that I can't convince the people in that room, then I need to just wait and prepare myself for court, right? That's where that kind of advocacy happens. So there are times, right, I will walk away from a meeting and say, okay, I'm not going to engage in an hour-long pre-perm. I'm not going to go back and forth with you because your position is very clear. I understand what facts you're using to make that decision. So I will prepare myself to advocate in a courtroom in front of the judge who actually makes that decision, right, about whether or not we're going to change the plan. When we're at mediations, who are we working with? Who are we advocating to? Who is, who's making the changes? And really, ideally, right, mediation should be everyone coming to the table and saying, the department making a proposal, and then the rest of us going, yes, that works, or I understand that, or I don't, or here are some issues that I'm finding. And that advocacy in that place, right, works a lot differently and does or should work a lot more interdisciplinarily. Working with this program, I think, is forcing us, or at least it has forced me. I've been doing FAP since I came onto the contract in Valencia, to shift our perspective about who is at that table, right? Up until the plan changes, everyone in these cases, everyone in the room, their goal is all of the same. We all are trying to reunify families. We are all doing our best to get families the services they need so that kids can go home where they belong. And that needs to be, I feel like, shaped and said over and over and over again till we remind ourselves and we remind our clients and we remind everyone in the room. We are all on the same page. We are all a team. We are all trying to get to the same place right now. And maybe 6 months down the road or 9 months down the road, that may change. But at this time, we're all supposed to be on the same team. So how are we all working on the same team to get a treatment plan that works best for this family, to get the services that work the best, and not overload parents or not put them in situations for things they don't need? And again, looking at this case in particular and what these kids came into this case for, and how can we alleviate those causes and conditions. Another place is family-centered meetings. And I feel like often we're not requesting them enough. I feel like a lot of times the department kind of says, oh, we're gonna have a family-centered meeting. And then everyone else shows up. But we have the ability to ask for those things too. If we see an issue or we want to address something, we can say, hey, can we all sit down and talk about this? I was thinking, we should be doing family therapy. So can we have a family-centered meeting with the kids therapist and the parents therapist and everyone from the department so that we can figure out a plan on how to do this most effectively so that we can move to the next step with this family? Family-centered meetings do not have to be called by the department. We have the ability to ask for them. And we should be if the timing is necessary, right? We don't have to wait for hearings. We don't have to wait for pre-perms or pre-adjudication mediations. We can at any time sit down, ask for a meeting where we can all sit down and meet together. And lastly, all the time, anyone on this call who knows me, especially workers and the PPWs and the social workers, will tell you, I will stop you in the hallway at court. I will text you and say, hey, I saw this thing, or I have this idea about this case, tell me what you think. Or I have this case fact scenario and I was thinking about doing X, Y, and Z. What is your input on that? And getting the input, I feel like getting the input from the department, getting the input from the social worker, right? One, that's what we're supposed to be doing. That's what an interdisciplinary team looks like. But the more that we are willing to engage with each other and say, and I will tell you, there are workers on this call who text me sometimes and say, hey, what are the legal ramifications of this? What happens if X, Y, and Z doesn't go? What happens in court the next time, right? The more that we are opening those lines of communication to ask each other for advice, to present something, and sometimes our ideas won't work out, right? And so we don't want to present them in front of a judge. So calling up the worker, calling up the social worker or the PPW and saying, hey, this is my idea, for them to say, oh, this is why this won't work, or this is why we're reluctant to do this way. Can you shed some insight so that when you go to court, you're not advocating backwards, right? I had a case recently where there are some concerns with the foster parents, but we're already at a trial home visit stage, and we're like in the calendar, the kids aren't home yet. And I was really frustrated after the meeting. And I reached out to the worker and the supervisor and the lawyer, and I said, what about moving these kids? And the department responded to me with some insight that I didn't have about, some of their concerns and the way that they were working the the trial home visit schedule to get the kids home. And I could have gone to court and I could have made an argument that I wanted these kids moved, and I could have, gassed up my client, and we could have gone in there all gung ho. And that could have been detrimental to our case if I hadn't taken the time to talk to the worker, to talk to the supervisor, to talk to the lawyer about what their perspective was, right? We have to be able to communicate and engage with each other so that we understand better. And all of that builds the relationship. And to me, that is the biggest part of this program, is the relationship building and the trust we have to build between each other so that we rely on each other, so that we trust each other's opinions, and so that when we get to a place where we are at a stalemate, where we don't agree, we at least have the respect and the courtesy for each other to understand and hear each other out. And then if we have to, right, file a motion for abuse of discretion or go and argue it in court if those things are necessary. Next slide. Why are we advocating outside of the courtroom? And this is clearly, right, like a slide for lawyers. And the reality is not every decision is decided by the judge, right? When we go in and we say, hey, Your Honor, we want visits, or that we wanted visits this way, and the department's not doing what we want, or we don't like this placement, like those, we're tattletaling. Like, it's not effective, right? Because the judge isn't making that decision. What the judge can make a decision on is abuse of discretion, right? So if we have an issue with visits or we have an issue with placement, we need to be exhausting all of these out of court advocacy methods so that we can file these motions and they'll be effective, because we have tried everything. We have made our arguments. We have had a family-centered meeting. We have talked to the therapist, and the department still won't budge in our direction. Then we file motions for abuse of discretion. But up until that point, when we show up at hearings and we talk about those things, we're just tattletaling, because we all know the judge is going to say what? Well, department, will you take a look at that, right? That's the most that they can do in terms of those things. So we really have to be on our A game outside of court when we're talking about these things that the judge does not make decisions about. And so visits, placement, therapeutic direction, and parental and school involvement, right? How much involvement are the parents having in school? Are they going to extracurricular activities? Is the therapist recommending no visits? Is the therapist recommending trial home visit? What are all of these things that are happening outside of court that can influence a motion for abuse of discretion? And how are we exhausting and going through all of those paths first, so that one, we are building a relationship with the people that we're working with on our team, right? We're going to them and we're talking to them and we're, fleshing these ideas out about what we want and what they want and why it won't be on track. And then we have something really concrete to put in our motions about, we met with the department, we offered this, the therapist says this, right? This is what the parents have been doing, in terms of extracurricular activities and host visits. And so now we think this is the appropriate time for X, Y, and Z, and the department doesn't agree. Then the judge can make a decision about abuse of discretion. And here we are back at relationship building again. How are we creating a stronger team with out-of-court advocacy? How are we engaging with each other so that we are, one, collecting knowledge, right? And we are making sure that we are getting the most knowledge that we can from the most knowledgeable people on our team about where it is we're going or what it is that we want to do in this case. And then how are we creating a trust and an amicable relationship, right? I can tell you, there are people in the department that I get along with great outside of the courtroom. I can tell you, we go into the courtroom sometimes and we do not agree at all, right? But it doesn't change the respect that I have for them, and it doesn't change the way that I'm able to access them and ask them questions, or that the way they feel about me, right? We're not always going to get along the minute we walk through that courtroom door. But outside, we should always be working to create the most friendly and trustworthy environment that we can, because our clients benefit from that every time. When the people on the department trust respondents lawyers, when the respondents lawyers are trusting the guardian ad litems and the YAs, when we are confident that everyone is on the same page and working towards the same goals, we are all a lot more willing to hear each other out. And that always is in the benefit of our clients, always. It never hurts our clients when we can have respect for everyone at the table, when we can hear everybody out, and when we can get as much from them as we possibly can. I was in a meeting yesterday where a family-centered meeting where the therapist came on and said some things contrary to what my client wanted and the kind of the direction that we had been going in. And when it came my time to speak, I, did my best to be honest and say, we as a team, right, we invited these therapists on. We created this big plan for these therapists. Dad has a therapist, kids have a therapist, they have a family therapist, they all work in the same location, they all share this information. And so if we're here now and this therapist is saying, these things that are contrary to what we want, then we have to listen to that. I don't feel strong enough in my position to argue with this professional, because we invited them here and we asked for their opinion. We asked them here because we trusted them. And so maybe this isn't going in the direction that I wanted or that my client wanted, but I have a level of trust and respect for this person who's doing this job, and they're telling me that we're not there yet. And that's sometimes something that parents don't want to hear, but they need to hear, right, to get them back on track and to make sure that they're doing the things they need to do. And it's something that everyone in the room needs to hear, so that we can all understand that we are all working in the best interest of the child or the children, right? The lawyers are not showing up and trying to railroad what they want just because they want to win. And they're not doing it with disregard for the children, for their development, for what's in their best interest. They're doing it cognizantly, and they're doing it with a collection of information that ensures that we are doing what's best for the family as a whole, and really what's best for the development of the children. We talk so much about the family, but we have to remember, right, the adults in these cases are the adults and the children are the children, and we should always be focused on what is in the best interest of the children. Next slide. Teamwork makes the dream work. Who is on our team? So we have lawyers, social workers, parent mentors, permanency planning workers, supervisors, right, for the PPWs, supervisors for the social workers, supervisors for the parent mentors, attorneys for the other side and their supervisors, therapists, educators. Who are all of the people that are contributing to this family right now, that are doing their best to assess and help them? And then how do we get, the best of everyone so that we can help this family, pulling on all of these different resources? And most importantly, what do the people on your team know that you don't? How can they support your advocacy, either with their knowledge, or maybe they're the appropriate person to do the advocacy? Sometimes, I'll have an idea about something and I'll go to a worker or I'll go to a social worker and I'll say, hey, Kylie, I was thinking this thing, but I don't think I'm the best person to approach it. So do you think that from your end, you could do this with the PPW, and then from my end, I could email the lawyer on this and frame it this way? And how can we work both sides of this with our special skill set to get the result that we want, right? And even with the department, right? Maybe you have a department lawyer who doesn't want the same thing that their client wants. And so going to their client and saying, hey, or sending an email and saying, this is kind of where we were at. What are your thoughts on this? and allowing the worker to say to their counsel, you know, no, I think what this lawyer is saying is really the better path. I think that gets us the result that we want, not this other way that we've been going. And all of us in here have seen CCAs, I don't know if there's any CCAs on this call, but CCAs who do what they want to do over what it is that their client wants for the case. And so in building those relationships with the PPWs and with their supervisors and being able to go to them and talk to them, we create a new avenue of advocacy, right? And because the department has ultimate discretion on some of those things, that is the place we want the advocacy to come from. We want to be able to show the workers and to show their supervisors and to show their lawyers why this route is the best route, because they can do the advocacy internally and then we don't even have to do it. Next slide. Oops, I thought I could do it, but I didn't. Okay. So book suggestions. So going back to what I was talking about at the beginning about where are we getting knowledge? How are we accumulating the knowledge that we need to make the most informed positions for our clients? So here are a couple of books that I've read since I've been on the contract that have kind of allowed my perspective to shift around trauma and attachment bonds and just the overall perspective of this system, you know, and everyone that's involved with it. So Childhood Disrupted is a book based on ACEs scores. And ACEs scores are adverse childhood experiences. It's a 1 through 8 score. It's a simple test. You take it, and then at the end, you add up your numbers, and it tells you where you fall. And it can give you insight. There's correlation between ACEs scores and different kind of medical and psychological issues that people develop over life. So when we're looking at those things, when we are knowledgeable about ACEs scores and we are knowledgeable about trauma, then when we are going into these places and when we're going into meetings and when we're having FCMs or we're going into court, we can pull on that if we have a firm understanding of it, if we've been researching it and we've talked about it and we've explored it with our social worker about kind of what does this look like, and then what are the adverse effects that we're setting people up for if we're not having visits more often, if we're breaking the attachment bond, right? If we are doing visits in a way that is not the most conducive for the attachment to exist or to grow or to reattach. And so these books I have found incredibly helpful. Attach: The New Science of Adult Attachment talks about the 3 main forms of attachment that are exhibited in adults. So when I read that book, it's applied to adults, but they talk about how, what the symptoms are or how those things manifest. And children are not different from adults other than their frontal lobe is not fully developed, but they're still people, right? And they still have the same responses to things, to stress. They still have anxiety. They still have nightmares. Like when they are in a stressful situation, you will see their responses and their trauma responses. They don't look much different than adult trauma responses, other than maybe we're a little bit better about silencing them and keeping them quiet, and they're not. And this goes back to the visits. And when I was talking about earlier about what are the reactions that the children are having to the visits, right? Are they having issues beforehand? Are they having issues during the visit? Are they having issues afterwards? How are we keeping track of that stuff? How are we seeing that? And how are we seeing them differently, right? So some things are trauma responses. Some things are normal responses under the circumstances. But if we are not taking the time as advocates to learn about these things, then we're a step behind when we go into courtrooms. We're a step behind when we go into meetings with therapists and social workers and PPWs who are speaking in this language a little bit more frequently than we are. We have to be up to date so that we can say, I think that looks more like a normal response after a visit, not a trauma response. So I don't think we should be cutting back visits at this time. And if that's the route you want to go, then I want a therapeutic recommendation saying that. I know oftentimes we get into those discussions and they'll say, oh, the kids are having nightmares or the kids are crying after visits. And not that those things aren't important, but if we lack the understanding or even the base knowledge about what those things are indicators of, and we can't have a conversation about them, then we're at a loss and our client's at a loss. Because what do? We're saying, well, the kid's crying and they're saying the kid's being hurt or the kid doesn't like it. I don't know what to do about that, right? And the visits are up to the department's discretion. So if they're saying no, I get your kid to stop crying when you see them, right? Like we are lacking the foundational knowledge to really advise our clients. And we're not counselors, we're not therapists, but we are supposed to be helping parents do their best in this situation. And part of that is for us to bring our best to the situation. And helping clients also understand, I think, when there are trauma responses and saying, hey, this stuff's not normal, man. And this is the thing that we need to work on. And this is some place where you can show some improvement. So why don't we talk about the next, X, Y, and Z things? What parenting class are you doing? I advocate all the time for Circle of Security Parenting. That is the parenting class that was most effective for me. I took that class. I thought it was great. It made a huge difference in my home. When I have parents in certain situations, when I can see that there is trauma and that the parents are going to have to be trauma informed, even if they've already taken a parenting class, I will advocate for this one too, because our goal, right, is for kids to go home and to not come back. And if we're not giving parents the tools to deal with the children coming out of the system, then we're setting them up on a path that is not successful. So we have to be knowledgeable in these things so that we can advocate for our client and so that we can counsel them correctly, so that we can help alleviate these causes and conditions so these kids don't come back. The Body Keeps the Score is about how the body internalizes trauma, holds it, stores it, and then how do we get rid of it. This book reminds me of a conversation that I had with Andrea, where she turned around and she used that conversation to advocate for yoga for her client, and the judge ordered it. There are plenty of spaces in trauma recovery, in healing paths that have nothing to do with talk therapy, that have everything to do with releasing the stuff from your body so that it can be gone. Everyone can't, one, remember the trauma that occurred to them, right? Our brain does all kinds of magic things to save us from ourselves, to save us from our pain. Two, everyone's not ready to talk about that stuff or has the language to discuss it. But there are other ways that we can help our clients and their children get back on the path to healing that has nothing to do with sitting them in front of a stranger and making them pour out their guts. And that book is a really good example of what options we have, how it happens first, how is our body storing this trauma, what are the results of it, what do those symptoms look like, and then how can we help ourselves or help the people around us heal from those things. And I'm just happy to be here is a memoir about a woman whose children came into custody. She was a drug addict. And it's about kind of her life story and how she got to that place and the decisions that she made when she got there, and then how she worked herself out of that situation, and what that looked like, really realistically what it looked like in terms of relapse and, the length of time that it took, and that her desire, right, really discussing that her desire to be with her children and be their mother was never, it never went away, but there were these other things that were just kind of drowning her that she could not get out of. And how did she have to reframe her life? I tell people all the time, 2 years is not enough time for people to get clean. Addiction is a lifelong thing that you deal with. And even once you're clean, it is still a lifelong issue that you deal with. So how are we gaining more knowledge in ourselves about addiction, about programs, about, the difference between IOPs and going into, inpatient and doing AA and, cognitive behavioral therapy, and like, what are we assessing knowledge on so that we can help our clients be most successful as quickly as possible. Traditional methods are not ideal in this time frame that we're stuck in. So we need to be kind of on what is the next thing? What's the next thing we can be doing? What will get us there faster? How can we help break these things down so that my client can get back to their kids as soon as possible? I had some other ones, but those were the big ones that I thought that I really found helpful that I still rely on in my practice. So I'm at 38 minutes. Is that good? Are we good? We want to do questions?
Yes. So let's see. Does anybody have any questions for Estelí?
But don't type them. Turn on your mic and say them.
Yeah.
I can hear someone laughing.
I have a question for you, Estelí, actually.
Okay.
You had mentioned sometimes in pre-perm conferences where if you know that the department is not going to change their mind and they're going a way that you don't really agree with, you'll just get up and leave. Like, you won't spend the whole hour talking about it if you don't think that you're going to be changing their mind. Yes?
Yes.
So I guess my question would be, and I've never done that, so that's interesting to me, because I'll sit there and I'll listen, and I'll sit with my client and listen to all of the explanation. When you do that, how do you explain to your client why you're not staying, you and your client are not staying for the rest of the meeting, and how does that conversation go?
So typically when I go into a pre-perm, I want to know right away, where is this boat heading? Where are we going? What's the plan here? Okay, you're going to change the plan. Tell me what your foundation is. Okay, the client's been missing services, right? Or, there are sometimes I will sit and I'll say, okay, well, what about this? Or what about that? I remember that they were, in the hospital for 3 weeks and they couldn't do this. But in the moments where I know that my client has been diligently working their plan, and I know that my client is, on task, and the department for whatever reason is saying, no, we think that this is not being met or this is not going to happen. I am more than willing to say, okay, thank you for that. I can see that we're not going to get anywhere in this conversation. I appreciate your explanation for why you're making this decision, but I think that we can be done now. And then I will take time to talk to my client and tell them the department doesn't make the decision about changing plans. The judge makes the decision. The department goes in and says, we want to change the plan, and these are the reasons why. But we also get to show up and ask for a hearing and say, no, we don't want to, and here are our reasons why. And that judge makes the decision on this. So arguing here till I'm blue in the face because you're not going the path I want to is a waste of my time and energy. It's giving up any sort of advantage that I have in my argument, right, by spilling all of my stuff out to them. And it's frustrating for my client. I think a lot of when we're in those meetings about what is it that my client is having to hear about themselves, what is it that they're being, that's being said about them, about their parenting. And if we are in a situation where I feel like we have a solid argument, I do not want my client to be traumatized and tortured by sitting there hearing about why the department doesn't think whatever they're doing is enough when they're following through with the plan as set forth. And I think those kinds of situations only create more contention. It's just not necessary in that moment. You've made a decision. You're not going to budge on it. I don't need you to talk to me for the next 30 minutes about why you think my client is not prepared. And my client doesn't need to hear that. If you're going to do that, and we're just going to go do this, and we'll do this in front of the judge. And if the judge doesn't decide our way, then there we are. But this is not the place where that decision gets made.
So, Estelí, this is Gail. I don't have my camera on. Can you hear me?
I can.
Okay. So I have the thought of this whole thing because I have one coming up for a client who is basically, I represent a parent and the parent is uncooperative and continually says, I've done everything. So, I don't know if he's going to come to the pre-perm, show up at the pre-perm mediation or not, but I keep trying to get him to hear from others what he needs to do to change that. So it's a different situation. It's not like in what you're describing, because I've had the situation you're describing where I think, the client's basically done everything. And, but here, I don't want to set any, for me, he keeps walking out of meetings with CYFD, and I keep trying to tell him he's only hurting himself, or he's only hurting the children. Because in some ways he's a good dad, but he's not doing anything. So I don't want to set that example of we're not going to sit here and listen to this, because I think he needs to do some serious listening. So,
and I agree, there are some clients and some parents, right, that do need to hear it. Oh, can you mute? Sorry. So kind of like the case I had yesterday, right, where the therapist said things that I don't think my client necessarily wanted to hear, but he needed to hear. I often find that guardian ad litems and youth attorneys can be the best allies when you have a parent that won't hear what the department is saying, right? Because that guardian ad litem and that youth attorney, right, they're the voice of the child. And so getting them on board to kind of, and remember we had that case together, Gail, where I sat your client down and I said, hey man, I need you to get your stuff together. I really like this kid and he really wants you to get your stuff together and come home. And I feel like a lot of times that is because the situation with the department can be so confrontational sometimes, having the lawyer there for the kids and hearing from the lawyer from the kids, I think can be helpful sometimes to parents to kind of shift their perspective. Like, this isn't just the department saying, I'm a bad parent or I can't do this, but my kid is saying, right, that there's something wrong, or that my kid is saying there's an issue and that they need support or that they need help with this. I find that to be a good place. I think when we're doing these FAP cases again, right, we're looking at a team. And so how can the social worker, how can the parent mentor especially, right, how can the parent mentor who's been through this process before and knows, right, what assholes, how awful the department can be, or how confrontational the situation can be, right? That's a great asset to talk to your client and be like, hey, hi, Renee. You know, this is what, you know, regardless of the department's perspective, we're not getting anywhere in this case right now. And so these are the things that are the concern, or these are the things that need to be worked on. And this is coming from, you know, the social worker, this is coming from the guardian ad litem, this is coming from a therapeutic place, somewhere that's not the department. Because so often we start off so confrontationally that parents don't want to engage, they don't want to talk to the department, they don't want to hear what they have to say.
Now,
So I think that's like the, go ahead.
I think I like your idea of using the guardian ad litem or youth attorney in that way with the client. But anyway, it's tough. Thank you.
It is. It's tough.
Estelí, I have a question about the, I'd like to hear from you what success you've had and what arguments you've used to get unsupervised visits right away. Because, you know, the department really resists that. They say they need to observe, there's this, there's that. And I say, look, unless we're talking physical abuse here, right? I mean, what's going to happen, right? So I'd like to hear from you kind of what successes you've had and what arguments you've found to be helpful for getting that done.
So successes are rare. This is still new. I feel like, though, when I'm advocating for unsupervised visits, right away, I want the age of the children. The bigger the kids are, the way I feel like the argument is way stronger, right? The child can self-protect. If they have a cell phone, they can call someone for safety. They can express what's going on in the visit. If we're not talking about, you know, a case of manipulation or psychological abuse or something like that, right? Then we're not worried about the mental safety of the child. But older kids, we can get there a lot faster, I think, than we can with younger kids, right? You need to, they want to supervise interaction with younger kids. And so it takes a little bit longer to get out of that space. But with the older kids, I think it's a lot easier. And if you have older kids and younger kids, I think that makes it a little bit easier too. Because then you have kids, right, that can report. And I've had kids in cases where I have advocated for kids to be on unsupervised visits, for kids to go home. And this was a case in the 13th. I don't think anyone on here is on that, out in Grant. But the older kid, one of the older kids came back and said, hey, dad's hitting the little kids, right? And so there, it worked exactly the way it was supposed to, right? We had one incident, the kid came back from the visit and said, hey, this is what's happening. And that's exactly how it's supposed to work if we want it to work, right? We send the kids out for the unsupervised visit, and God forbid, you know, something happens, that these older kids are able to report if there's an issue. And if not, then they don't, right? And they say, hey, the visit was great. We had a really good time. We baked cookies. It was fantastic. I can't wait to go back again. And the older the kids are, right, the more weight we put, right, on their perspective or what they, you know, what they're telling us. And so I think age is a big deal. I also think when we're talking about dirty house cases, if kids are coming into custody for dirty homes, right, that's not abuse, it's neglect. But it is more often than not a poverty issue, maybe some underlying mental health issue in terms of, you know, not being able to prioritize or get things done right. But often those parents are not actively harming their children. And so how can we get those parents at least back some unsupervised time with those kids in an outside location, right? Obviously not back in the home if the home's not suitable. Or if the home is suitable, right? I have so many cases. Kids come in on a dirty home of custody. By the time we reach adjudication, the house is clean again. So how are we getting those kids back into the house as soon as possible, even if it's just for short visits?
Thank you.
You're welcome.
Leslie, I'd like to address this. I really liked the survey we just had to take. And it made me think again, when CYFD at the custody hearing says, okay, we're gonna have supervised visits, and you're like, okay, what are your reasons for supervision? Make them squirm, make them give them at that time. If they don't have good reasons, if it's just, well, that's the way we always do it, then no, that's not a good enough reason. And we can advocate at that point that there needs to be, you know, this trial unsupervised visit to see how things go. I don't know, maybe it'll work.
Any other questions anybody have?
I have a question, Estelí, and of course I'm not an attorney, but I know that this comes up a lot where we're really advocating for more visits, but the department comes back with, well, there's no agency available, right? There's no place available. And so they put this roadblock in there. And so what is our avenue then? Because we know what's appropriate and what's best for the family, but then they're putting up this roadblock of, well, there's no one to supervise it, so it's not going to happen.
So visit hosts, right? That's why we're using visit hosts. We go back on, who in the community, who in the family can help in this way. Can we get their information to CYFD so that CYFD can vet them and make sure that they're comfortable with them. And in cases where I have clients who do make money, I will tell them to go to APN, go to neutral corners. If you want more visits and you can afford it, then pay for them. Pay for them to be supervised, because some clients can't afford that. And if they can, then that should be something that they're doing to show their commitment to the process if they can afford it. But I think visit hosts are the way that we go if the pushback is we don't have enough time or we can't afford that. Then here's a visit host. It's still supervised, and the kids are still, it's under supervision, and we're still getting the visits, and we're getting them more frequently, which is really what we want. Right? We want more visits for longer time. And I think the visit host concept is how we get to that place more often than not at this point. And so when we're talking about visit hosts, one of the things I want to talk about is how are we vetting them when we're asking clients who are our options? So making sure that the people and I want to present, 3 to 5 people, right, who are reliable, who are trustworthy, who hopefully don't have criminal backgrounds, depending on what the criminal background is. Sometimes I can argue around a criminal background depending on the crime, who have the time to do it, who are willing to, right, be safe, who are willing to have protective capacity as well and say, hey, this visit is not going safely. These parents are not doing what they're supposed to do. And we need to end this visit now. And you guys are right, this isn't ideal. And so we want to make sure that the people that we're offering as visit hosts are credible and have protective capacity, so that the department isn't just shooing them off every time. We need to provide people that are really substantial so that at least they have to look at them. And then if they don't, right, then we go back to abuse of discretion and we file motions and say, hey, we presented these things so that we could have visit hosts, so we could do these supervised visits this way. The department's not going to, they're not agreeing to it. They don't like our visit hosts, and we think that that's an abuse of discretion. And we go back to the filing. Is that helpful?
I think Nita has a question. Go ahead, Nita.
Estelí or anyone else in the forum, have you had any luck doing sandwich visits where the family checks in with the department at the beginning of the visit, they leave, they go have their own unsupervised community visit or go to the house or whatever, and then after the visit, they go back to the department and check back in?
So Nita, I've had a lot of success with sandwich visits. It's actually really been my kind of go-to to get to the unsupervised. It's been successful when I've advocated.
Was that in Bernalillo County, Catherine?
Bernalillo and Sandoval.
I've seen them when we're at a trial home visit stage, Nita, so that when when we're getting to that point where we all see something like that, I think they're effective. I haven't seen them earlier on though, and I would like to try that idea if it's possible. I will be adding that to my repertoire.
I think so. At a lot of the conferences that we've attended that are interdisciplinary parent representation conference, we've talked a lot about sandwich visits at those and using them when there's no history of substance abuse and the parents have the causes and conditions were based on neglect that brought the kids into care and not any type of abuse. And that's really their go-to type of visitation that should be occurring in those cases, if not unsupervised time. A lot of times sandwich visits can help the department feel a little more comfortable with it if parents are there before and after, and that's why we utilize them a lot.
Can anyone from the department talk about their concerns that they would have about the concept of a Spanish visit, a sandwich visit?
This is Megan. I mean, I don't have any major concerns about looking at sandwich visits for most of our cases. I would just say, and this is just my opinion, it would not hurt to ask my staff or myself to try to do sandwich visitation. I know right now in one of Andrea's cases before the Supreme Court order, we were doing visitation in mom's home, and it was unsupervised and some things came up. So we actually had someone go supervise at the home, but we kept it in mom's residence.
Megan, this is Nita. I have a question. When you have a parent who's had substance abuse issues, but it seems to be, I guess, tapering in terms of their use and things are getting better, how would you handle that in terms of a sandwich? Is that even a case you would consider a sandwich visit for? Or like, what would be your concern and how would you mitigate those concerns? How would you want the parent to demonstrate that substance abuse isn't going to be an issue at that visit?
That's a tough question. I think that substance abuse would be one of my concerns, especially if the parents are going to be transporting. So I think we would want the substance abuse to be resolved. And I think that Caitlin mentioned it earlier about, sandwiching visits when the major issue is neglect. I think it's more about a comfort level and a safety level. I mean, are we feeling comfortable knowing that the parents are going to transport? I mean, we need to know if they've been using because they're going to be in the car with the children. So those are the kinds of things that we kind of think about. But I know in other cases, we've transported to the home, we've supervised in the home, or we've dropped off. But I mean, every case is different. So I don't know if I would be able to answer that in like a general context and not like a case specific one.
I want to mention too that even if substance use has been part of the case, it doesn't mean that you can't advocate for sandwich visits. It just means that the parent's probably going to need to show some sobriety before you do that. And then it gives the department too the comfort of being able to check in with them before they take the kids with them, see if they're sober or not, and then be able to have that visit.
So I'm not stopping the conversation. I'm just giving everybody a heads up. It's almost 1 o'clock. So if you do need to check out at 1, just giving you a reminder. Hey, everyone.
If I can, I wanted to build on what Caitlin just said with that sandwich visit concept. I was back when I was practicing, I was never a fan of UAs for a visit, but maybe this is a circumstance if you do have a question about substance abuse where it is appropriate to do a quick check before they take the kids. The other question I have maybe for a department member, if possible, is what about an unsupervised visit, but where there's 1 or 2 phone calls or FaceTime or Skype check-ins during the course of the visit?
Do you want me to answer that? This is Megan. Or do you want me to give my 2 cents? I mean, I personally would be open to that, but I think it's just kind of hard, Kristen, with just giving like a general answer to situations. But I mean, I would be open to having that conversation. I mean, I can only speak for myself. And I mean, I think that, I've been talking to my team about Cornerstone and how important placement and relatives and visitation and all those things kind of can, how they all connect and how important it is regarding visitation. So I personally don't mind when I'm challenged about visitation and increasing visitation and, kind of thinking outside the box. So, I mean, I'm open to that feedback and trying different things.
Any other questions for Estelí? All right. Any
Okay,
other?
if not, I'm gonna go, guys. I have to go do my shopping. Today's my shopping day. But thank you all. If anyone has any questions, feel free to contact me. I'm glad that I did this and it's done now. I appreciate the opportunity to do it. And yeah, if anyone has any questions or any follow-up, or you want to talk about books or anything like that, or parenting classes, I'd be more than happy to do that. I wish you all great health and have a great day.
Thank
Thank
you.
you.
Bye, guys.
All right, everybody, just remember to complete the post-session feedback form. Jen posted the link to that on the chat, so you can cut and paste that into your computer and make sure that you complete that. Our next NMFAP Echo Didactic session will be on May 19th, and the topic will be cultural competency in child welfare cases. If anyone wants to stay on the line and just kind of talk about different ideas or anything like that, if you haven't covered something or you want to follow up on something, you're welcome to do so. But thanks everybody for participating today. Bye.
Thank you, Jen.
Bye.